Hello and welcome to Preventing Harassment and Bullying in the Workplace. This is Session A.
Session B is for managers and supervisors, and that will follow.
This class is part of your organization's mandatory harassment prevention training class. Thank you for your participation. Plan on spending the next hour watching this video and taking the test. I'm Marcia.
And I'm Philip.
And we're ready to get started with the training.
This course is brought to you by capreventharassment.com, and it is dedicated to a professional and respectful workplace. There are 5 objectives to this course. The first, build skills to resolve employee issues.
Employees invariably have issues that come up, and we want to make sure that you know about your resources and tools available to you.
Objective number 2, increase employee morale and productivity.
Employee morale affects everything that we do, not just productivity, but also commitment, quality, customer service. Those are all very important aspects of your employment at this organization. We want to make sure that your workplace is inclusive and respectful. Cool.
Objective number 3, learn about your policies.
We want you to know about our policies and ensure that we are consistent in the application of those policies, because the minute we're inconsistent, someone could say that we are unlawful or discriminatory, and we certainly don't want that to occur. Having a policy manual ensures that we are consistent across the board.
Objective number 4, increase professionalism as an organization.
If we're professional and respectful, we shouldn't have any issues. So that will be our goal.
Objective number 5, comply with the law.
There are many laws you should know about, both on the federal level and the state level, that give you rights and responsibilities, and we'll go into that in great detail. While this mandatory training is required by law, there's certainly a lot of other good reasons to make sure everyone is on the same page.
With those 5 objectives, the end result will be to help create a healthy and respectful workplace.
Let's go over what to expect in the training class.
The process for this course includes a video and a certification test. For the video, we'll watch this video and take notes.
At 2 separate times, we'll provide you with codes, and those codes will be evidence that you've actually watched the whole video. And then we'll go to the certification test. You need to return to the website, take the test, which will include multiple choice questions, and pass the test at an 80% rate. Also, we'll provide you with ongoing support, so you can always access us through the website. Managers, supervisors, and team leaders will follow the same process for Session B. You watch another video and take a separate certification test. At any time, please email us with any questions that you might have. As we all know, there's a heightened awareness of discrimination, harassment, and unfair treatment in society, with movements like Black Lives Matter, Time's Up, and Me Too, and recent U.S. Supreme Court decisions protecting the rights of Americans based on sexual orientation and gender expression. Employers must take serious their programs regarding diversity, equity, and inclusion, and individuals must ensure that their behavior is professional and respectful, or face damage to their reputations and possibly their careers.
Harassment is not new to employees.
Day 1, employees receive a brochure put out by the Department of Fair Employment and Housing having to do with harassment in the workplace. Employers are required to post posters in a central location. We also have a policy manual which details all of our policies and practices. We've done trainings in the past, but by following our policies, we demonstrate that this topic is very important. While most of this training is regarding sexual harassment, we'll also talk about other forms of harassment. We'll touch on the topic of discrimination and the need to keep everything fair and consistent. Also, the topic of retaliation and abusive conduct or bullying in the workplace will be covered in this short training. So let's get into the training. The first topic is going to be legal issues, which will talk about the rights and responsibilities that you have. Secondly, we'll talk about behavioral issues, how you should communicate and interact with your coworkers. And thirdly, we'll talk about some practical issues, what you should do or say if you've observed or have been victimized by harassment in the workplace. Our goal with this training is to educate you about the rights and responsibilities you have in the workplace, but also to give you some ground rules for professional and respectful interactions at all times, and certainly to give you resources in case there is an issue that comes up. Thank you for listening and taking this topic seriously. Now let's get into the first section, which is legal issues. In this section, we'll talk about legal issues and the many laws that provide you with rights and responsibilities. We'll discuss the legal issues having to do with discrimination, harassment, retaliation, and abusive conduct, or otherwise known as bullying in the workplace.
There are both federal and state laws. Federal, there are U.S. Supreme Court cases and U.S. EEOC Guidance. State laws, we have the California Fair Employment and Housing Act and various assembly bills and Senate bills that provide oversight.
Let's talk about the recommendations from the U.S. Supreme Court and the EEOC to do this training.
In 1998, the U.S. Supreme Court had two landmark decisions that strongly encouraged employers to conduct harassment prevention training.
Those cases were Burlington Industries versus Ellerth and Farragher versus the City of Boca Raton. And in both of those cases, the employer was able to demonstrate what's called the affirmative defense, because they took reasonable care to prevent and respond to the harassment that occurred. In both of those cases, the employees unreasonably failed to take advantage of any preventive or corrective opportunities available to them. Those cases demonstrate that employers should take proactive steps to avoid liability. In 1998, the EEOC provided a three-pronged approach as guidance for employers for preventing harassment. First, employers should adopt specific policies about sexual harassment, including a definition of harassment with real-life examples, language about non-retaliation for those who come forward with complaints, and also a statement that sexual harassment will lead to disciplinary action up to and including termination.
For complaint handling, complaints of sexual harassment must be promptly, vigorously, and honestly investigated, and valid complaints must be remedied. Employees must be offered multiple avenues of complaint.
And number three, the EEOC suggests that employers should consider training all employees, from the CEO to frontline employees, to ensure that they are sensitive to the issues of sexual harassment. The EEOC has strongly encouraged employers to do the training, but California has taken it a step further, requiring 2 hours of training every 2 years for anyone in a management, supervisory, or lead position. This law is called AB 1825. New supervisors who are promoted must be trained within 6 months, and participants must have the opportunity to ask questions, which we're providing for you through the website. Your questions can be submitted to us through capreventharassment.com. In addition to discussing sexual harassment, AB 2053 requires us to discuss the topic of abusive conduct. And abusive conduct is defined as conduct of an employer or employee in the workplace that's done with malice, that a reasonable person would find to be hostile, offensive, or unrelated to an employer's legitimate business interests. The abusive conduct could be from supervisor to their employees or vice versa. It could be peer-to-peer or from third parties such as contractors, consultants, vendors, suppliers, that sort of thing. Abusive conduct is not a one-time only event unless it's particularly egregious, but it could be the intensity or the frequency of the abusive conduct that's called into question. It's not necessarily a legal issue, but certainly disciplinary action could occur. Another California law passed in 2017 pertains specifically to gender identity and gender expression. It's called SB 396. This law requires employers to include this topic in training and also to display a specific poster entitled Transgender Rights in the Workplace. The intention of the law is to honor an employee's gender identity and gender expression. So employers are required to allow employees to use the facilities that correspond to their own gender identity, and requires employers to enforce dress codes in a non-discriminatory manner. Employers may also not ask questions in an interview designed to detect a person's sexual orientation or gender identity. The newest law relating to harassment prevention training is SB 1343. This California law was passed in 2019. It expands the training requirement to most employers, so now employers with 5 or more employees need to train their staff for 1 hour by January 2021. Temporary or seasonal employees must be trained within 30 calendar days or 100 hours if the employee will work for less than 6 months. Here's a list of the federal protections that are afforded to employees. So basically, you cannot be discriminated against or harassed on the basis of race, sex, color, religion, national origin, ethnicity, or ancestry. Additional laws provide additional protections such as age 40 and above, pregnancy and related medical conditions, military status, disability, immigration status, and genetic information. We'll go through each of these laws in successive slides. So sexual orientation and gender identity were recently determined to be protected under federal law. The major federal law is Title VII of the Civil Rights Act of 1964, which prohibits discrimination and harassment based on race, sex, color, religion, national origin, ethnicity, and ancestry. It also expands to sexual orientation, gender identity, and gender expression. Pre-employment inquiries are restricted, and promotional opportunities in the organization are subject to these rules. Employers are required to provide reasonable accommodation for the expression of religious beliefs, and this law also applies to organizations that have operations outside of the United States. Another law pertaining to discrimination and harassment is the Age Discrimination in Employment Act. It protects employees over the age of 40. It was the ages 40 to 70, but then the upper limit was removed. So like Title VII, it applies in hiring and promotional opportunities within the organization. So in terms of hiring, no questions can be asked about high school graduation dates or age, but it's okay to ask about college graduation dates. But also like Title VII, it applies to harassment as well. So no jokes or comments or teasing about age. Another law is the Pregnancy Discrimination Act, which protects people who are pregnant or have related medical conditions, such as miscarriages, infertility, or an inability to become pregnant. The only exception to that would be whether the qualification was a bona fide occupational qualification, which is a very limited exception. Under the Uniform Services Employment and Reemployment Rights Act, an employer cannot discriminate based on military status. Employers must hold the job open while the employee is out on active duty and reinstate them to the same or a similar position upon their return from leave. The Americans with Disabilities Act was a major piece of legislation passed in the 1990s. Employees that are covered have a physical or mental impairment that affects a major life function, such as seeing, walking, hearing, breathing. Employers are required to provide reasonable accommodation, but this accommodation can only be determined through an interactive process, which is handled by an individual such as HR or in your benefits department. This law also restricts medical inquiries to designated personnel, So make sure if you have access to any information that you keep it confidential and be respectful of employees' rights to confidentiality regarding their medical condition. And the Immigration Reform and Control Act has an anti-discrimination provision. It's not an EEO law per se, but it does have a provision which prohibits discrimination based on citizenship status. So yes, we need to verify an employee's eligibility and authorization to work with an I-9 form upon hire, but while they're an employee, we cannot treat them differently because of their citizenship status. And in 2008, the Genetic Information Non-Discrimination Act was passed, making it unlawful to discriminate against an employee on the basis of genetic information. So those are the federal protections afforded to employees. On the California landscape, it's much different. We're a very progressive state, we're very pro-employee and pro-labor, and we've always been very multicultural. We have a full-time legislature that promulgates laws to protect employees. Some states have similar protections, but no state has more protections than the state of California. Also, it should be noted that our state is very litigious and we have a very active plaintiffs' bar.
California Department of Fair Employment and Housing has 17 protected categories. They include race, color, religion, national origin, sex, gender, ancestry, gender identity / gender expression, sexual orientation, marital status, medical condition, military or veteran status, disability, age, and that's 40 or older, genetic information, political affiliations or activities, status as a victim of domestic violence, assault, or stalking, and the final, request for leave, family care, pregnancy, or an employee's own serious medical condition.
More information on your rights under all of these laws can be found on the employment posters hanging in the workplace or on the DFEH website, and a link to that can be found on the capreventharassment.com website. To summarize the information in this section, recognize that there are many laws, both federal and state, that provide you with rights in the workplace, but you also have responsibilities. Your responsibilities are obviously to do your job, but also to behave in a way that is conducive to the standards of conduct that are listed in your employee handbook or personnel policy manual, and be sure that you're not infringing on the rights of others in the workplace. As we mentioned in the beginning, you'll need this code for the middle of the session. It is CRFXV. You'll need that code to provide evidence that you're watching the entire video. That summarizes the legal issues section. Now let's move into the second section, which is behavioral issues.
Section 2, Behavioral Issues. Follow the standards of conduct and be respectful and professional.
From a behavioral standpoint, there's several issues that can get employees into trouble. This usually happens between interactions and communications with your coworkers. The first issue is profanity. Obviously, profanity entails anger and emotion, and there's no place for it in the workplace. Also, jokes. Jokes are fun. However, sometimes people are the butt of jokes, or jokes are made at people's expense, and so those are jokes that are going to cause you issues. Yelling or raising your voice indicates a lack of control over your emotions. So when there's the intensity and frequency of raising your voice, that could be problematic. Also, name calling. You should not engage in names that are going to be offensive to other people, and this would include calling people names like honey, dear, sweetie, babe, those sorts of things. Be careful about your electronic communications via email, Facebook, Instagram, Snapchat, social media, and even online games. Recognize that behavior that may be socially acceptable, such as flirting and joking, is probably not appropriate in a professional setting. So be aware of your behavior and act accordingly. Sometimes some of our communications and behavior has a bit of bias in it. There's prejudice or preconceptions or assumptions that we make about people. And there's also the element of unconscious bias, microaggressions that are comments that are made that don't intend to offend or humiliate or embarrass people, but that's the end result. So we need to be cautious of those sorts of comments and behaviors.
So let's start with the impact of harassment. And first with the impact on individuals. Physical and emotional stress and health issues are one element of harassment. Second, impact to self-confidence and pride in work. And a third, but not final, is the job, career, reputation. Another impact is on the team. There's poor team cohesion, lower productivity, loss of morale, stress, and interpersonal conflict. The third is impact on the organization. Cost of investigations and settlements, liability, high turnover and loss of valuable employees, negative publicity, and loss of contracts, grants, public trust, and confidence.
For all those reasons, we want to ensure that people's behavior is appropriate, respectful, and professional. We're now going to talk specifically about sexual harassment, but first, just a couple of general comments. Remember that harassment can be based on other elements, not just sex. It could be based on race, color, religion, or any of the other protected categories that we talked about. It is subject to interpretation because we are different people with different backgrounds, different genders, different ages. We all have different senses of humor and different tolerance levels. So what offends or humiliates one person might not offend another person. However, it is subject to the standard of the reasonable person. Would a reasonable person be offended given the circumstances? And certainly if anyone tells you that they're offended, you need to stop that behavior at once. There are 4 types of sexual harassment. The first is sexual favors or quid pro quo. That would be a manager or supervisor abusing their power by saying something like, if you do this for me, I'll do this for you. Or if you don't do this for me, I won't do this for you. The other forms are physical, verbal, or visual. The California Administrative Code of the Fair Employment and Housing Commission defines sexual harassment as unwanted sexual advances, offering employment benefits in exchange for sexual favors, or making or threatening reprisals after receiving a negative response to sexual advances. So to provide you with some ground rules, here are some case scenarios in the healthcare field. Scenario number 1, joking at work. 2 employees are observed talking in the hallway outside a patient's room. Both are laughing and engaged in the conversation. Employees should be cognizant of their behavior at work. They shouldn't be joking about another person or making comments that demean, embarrass, or offend another employee. And from a customer service standpoint, they should only engage in professional behavior at work, particularly when around others. And obviously, always keep HIPAA confidentiality issues in mind as you are working. Scenario number 2, complaints. An employee has complained about unfair treatment, so the supervisor is unsure how to treat them and ends up avoiding the employee. The answer is the hospital or facility has a complaint handling procedure which should be followed. An employee has the right to complain and should not be treated differently as a result of that complaint. Ignoring or ostracizing the employee or changing the terms or conditions of employment could be considered as retaliation. Scenario number 3, electronic communications. You're friends on Facebook with several other employees and you notice inappropriate postings about a coworker. The answer is, employees should be careful about their electronic communications on social media like Facebook, Instagram, Snapchat, or others. Disclosing confidential information and communications that are disparaging or disloyal to the employer may certainly be restricted on your social media policies. Scenario number 4, hugging. I'm a hugger, says your coworker, and bestows hugs on patients, coworkers, and anyone else they encounter. The answer is that in healthcare, it's natural to hug patients or coworkers to express sympathy and empathy. In these circumstances, it's likely fine. However, hugging 3 times a day every day may be excessive. Hugging can create a hostile work environment when it is unwelcome and pervasive. Good rules of thumb are you can probably hug your close friends, but not all the time. You can probably hug someone if you ask and they say it's okay. But you shouldn't hug someone you supervise, and you shouldn't hug a coworker with whom you're romantically involved. Scenario number 5, body language. An employee stares, gives mean looks, or wags their finger and becomes visually angry with her coworkers. Certainly, this type of behavior would not be considered to be professional. Verbal, visual, and physical displays of aggression could create a hostile work environment. Scenario number 6, friendships at work. Your coworkers are friends and end up spending weekends and evenings socializing. Several romantic relationships have resulted on the team. Obviously, it's fine to have friendships with people that you work with. And although we cannot control staff's lawful off-duty conduct, employees should refrain from public displays of affection or excessive socializing. They should also realize that their conduct could be questioned should the behavior come into the workplace. Scenario number 7, dating. An employee asks another employee out and they have said no, but she repeatedly asks them out for a date. The answer is, you spend a lot of time at work, and it's logical that you may meet someone that you want to become romantically involved with. However, if you ask an employee out for a date and they say no, do not repeatedly ask them out. Also, employees that do not report to each other could date, but should be aware that their romance could go sour, so be cautious. Scenario number 8, compliments. A coworker tends to give you compliments on a regular basis, saying things like, "Hey, you look great. Have you been working out?" The answer is that compliments may be misinterpreted due to the tone, content, frequency, and intensity of the attention, among other factors. If the person has said they are uncomfortable being complimented, do not continue this sort of attention. And remember that all workplace communications should be professional. To summarize this section, remember that you have to understand the ground rules of communication and interaction. And the key is to be respectful and professional at all times. Try not to excessively socialize with your coworkers, except for on breaks or after hours. This also applies to your interactions with vendors, suppliers, customers, patients, and management.
Section 3, Practical Issues, Resources, and Next Steps. So the employee responsibilities are read the policy, review posters, uphold standards, and remind others about the policy or refer to appropriate persons.
We've talked about a lot of the rights that you have in the workplace, but you certainly do have responsibilities as well. Your employee handbook is a great place to look in case you have any questions about the behavioral standards. Also, the set of employment posters that are hanging in a common space are a very good resource for you as well. They include information of the agency that's responsible for that law, as well as contact information. Your organization has a lot of policies that are important in your employment. There's an EEO policy and a policy regarding harassment and bullying in the workplace. There's also a complaint handling procedure, and of course other policies such as standards of conduct, dress code, confidentiality, and your social media or electronic communications policy. So read the policy manual and understand what's required of you.
When it comes to reporting harassment, speak up if you know or suspect a situation. Second, multiple avenues of complaint exist. Through human resources, your manager, supervisor, manager, or executive, or anyone really in a management position.
Remember, it's the employer's responsibility to investigate any claim of harassment promptly, vigorously, and honestly. But we need to know about it, so it's your responsibility to speak up if you know or suspect a situation that's going on. It's your choice who you want to go to with any complaint, concern, or question. You could even submit the complaint anonymously. However, it's very difficult to investigate a claim if we don't know specifics. Oftentimes, employees are hesitant to come forward with information regarding a complaint or situation, but you should know that your organization's policy includes a non-retaliation provision, meaning you can't be retaliated against for coming forward with that information. Employees do have the right to complain, and we want to be respectful of that, but certainly you should not fear retaliation for complaining or even being involved as a witness in an investigation. If that occurred, that would be an example of retaliation. A synonym for retaliation is revenge or payback. Your organization has an investigation process in place which requires employees to report the conduct as soon as possible. One thing to mention is that we cannot ensure 100% confidentiality. However, we will only share information with people who have a demonstrated need to know. And employees should try to maintain the confidentiality of their information as well. So in summary, we want to make sure that you're aware of your conduct and how it impacts other people.
Understand the legal issues, rights, and responsibilities.
Make sure that you separate your professional behavior from your social behavior.
And last but not least, seek advice from HR or your manager if you have a question, comment, or concern.
That concludes the video component of this 1-hour training class. The rest of the time will be composed of a final activity as well as the certification test, and that should take you to the full hour. The final activity is to review the posters in your workplace, or you can also find the posters linked on the capreventharassment.com website. There's a sexual harassment brochure as well as a poster put out by the DFEH that is entitled Discrimination and Harassment in the Workplace. Now you're ready to go to the certification test. The code for the end of the session is CGFRX, and you're going to want to write that down because that is one of the test questions. When you go to the capreventharassment.com website, click on the test for session A. Enter your name as you would want it to appear on your certificate, as well as your email. The certification test consists of 10 multiple choice questions. They're not that difficult. They are just meant to ensure that you have comprehended the material in this short video. As we mentioned, you need the code from the middle of the session as well as the end of the session, and you have to answer at least 80% of the questions correctly. If you do so, a certificate will be generated and an email will be sent back to you, and a copy will be maintained for your employer.
There's a variety of resources available. Department of Fair Employment and Housing, their website is www.dfeh.ca.gov, and there's contact information on your company poster.
You can also contact us at capreventharassment.com or via email at capreventharassment@gmail.com. We will respond to your request within 2 business days.
Thank you for participating. Managers, supervisors, team leaders also must take Session B video and test.
Session B follows basically the same process where you will watch a video, do a final activity, and take the certification test. Thank you for your participation, and we appreciate your attention to this very important topic.